Welcome back to SCOTUS Oral Arguments and Opinions. Today, we're continuing our season preview and diving into Villareal versus Texas, a case that's generating significant interest among prosecutors, criminal defense attorneys, and trial judges across the country. And while this case might not have drawn the massive amicus brief attention like some others this term, it's tackling a fundamental question that affects every criminal trial where a defendant takes the stand. What happens when testimony gets interrupted by an overnight recess?
I'm excited to discuss this case today because it seems like it can profoundly alter the dynamic when a person testifies in their own case. So let's set the stage. At its core, we have David Villareal, who is on trial for murder in Texas, claiming self-defense after stabbing his live-in boyfriend, Aaron Estrada. Villareal was the only defense witness, and his testimony began just before noon one day.
And here's where it gets constitutionally interesting. About an hour into his direct examination, the trial judge had to recess for the day because of a previously scheduled administrative commitment. So we've got an overnight break right in the middle of Villareal's testimony.
The judge was worried about coaching. Basically, that defense counsel might use this overnight break to tell Villareal what to say when he resumed testifying the next day. So the court issued what's called a qualified conferral order. The judge told Villareal and his attorneys that during the overnight recess, they couldn't discuss his testimony. But here's the twist. They could discuss everything else.
Right, the judge said something like, suppose we go into a sentencing hearing and you need to start talking to him about possible sentencing issues. You can do that. The court attempted to balance protecting the defendant's right to counsel and preventing improper coaching. The judge's exact words were pretty telling. He said, ask yourselves before you talk to him about something, is this something that manages his testimony in front of the jury? So the court was trying to distinguish between managing testimony versus discussing other trial matters.
And defense counsel seemed to understand this distinction, at least initially. One attorney said, we aren't going to talk to him about the facts that he testified about, though counsel did preserve a Sixth Amendment objection just for the future. So Villareal resumed his testimony the next day, was convicted of murder, and sentenced to 60 years. But this overnight conferral issue became the centerpiece of his appeal. The Texas Court of Appeals affirmed the conviction. This court held that the trial court successfully threaded the needle by allowing discussions about all trial-related matters, except ongoing testimony. The Texas Court of Criminal Appeals affirmed by majority decision. This court held that the type of communication being restricted is the true controlling factor, not length of recess, and distinguished between discussing ongoing testimony, prohibited, and taking consideration of testimony when discussing other matters, permitted. One judge dissented, finding the order equivalent to the unconstitutional prohibition in Gators. Villareal appealed the case to the Supreme Court, and the highest court in the land agreed to hear his case.
And that's where we get into the really interesting constitutional territory, because this issue sits right at the intersection of two major Supreme Court precedents that seem to point in different directions. But first, let me read our listeners the key constitutional text that's at the heart of this dispute. This is from the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense.
You know, that language is beautifully straightforward. The assistance of counsel for his defense. No exceptions, no time limits, no subject matter restrictions, just assistance.
Exactly. And that's what makes this case so fascinating constitutionally. The question becomes, does that assistance include the right to discuss your ongoing testimony with your lawyer during an overnight recess? Because if it does, then Texas has a problem.
And I noticed that the Sixth Amendment doesn't say assistance except when you're testifying, or assistance but not overnight. The text is broad and protective.
Excellent point. Let's talk about those precedents because they're absolutely crucial to understanding this case. We've got Gators versus United States from 1976 and Perry versus Leak from 1989, and they're like constitutional bookends. In Gators, the court held that a trial court violates the Sixth Amendment by completely prohibiting a defendant from speaking with counsel during an overnight recess. The court said that overnight recesses are oftentimes of intensive work, with tactical decisions to be made and strategies to be reviewed. But then, in Perry, the court held that during a 15-minute recess, a trial court can completely prohibit the defendant from consulting with counsel. The court said that during brief recesses, there's a virtual certainty that any conversation between the witness and the lawyer would relate to the ongoing testimony.
So we've got this bright line. Long recess equals right to counsel. Short recess equals no right to counsel. But here's where it gets tricky. What about a partial restriction during a long recess? And that's exactly the constitutional gap that Villareal versus Texas is trying to fill. The lower courts are split on whether you can have these qualified conferral orders that let defendants talk to their lawyers about some things but not others during overnight recesses. The federal circuits have generally said no. Any restriction during an overnight recess violates Geters. But several state Supreme Courts, including Texas, have said yes. You can restrict testimony discussions as long as you allow everything else.
So the court granted cert on this question: whether a trial court abridges the defendant's Sixth Amendment right to counsel by prohibiting the defendant and his counsel from discussing the defendant's testimony during an overnight recess.
Notice how that question is framed. It's already characterizing this as prohibiting discussions, which tends to favor Villareal's position. But Texas would probably reframe it as preventing coaching while preserving all other constitutional rights.
Let's dive into how each side makes their case, because they're seeing completely different constitutional landscapes here.
Villareal's argument is actually pretty straightforward. He says the Supreme Court already answered this question in Perry, which stated that defendants have unrestricted access to counsel during overnight recesses, and the fact that such discussions will inevitably include some consideration of the defendant's ongoing testimony does not compromise that basic right.
That's a pretty powerful quote for Villareal. The Supreme Court literally anticipated Texas's argument and rejected it. Perry said that overnight discussions will inevitably include testimony considerations, and that's constitutionally protected.
But Villareal's strongest argument might be practical rather than textual. He argues that you simply cannot separate discussions of testimony from discussions of trial strategy. They're inextricably intertwined.
Can you give us some examples of that?
Sure, say the defendant's testimony is going badly, and counsel thinks he should take a plea deal that's still on the table. The defendant asks, "Why should I take the plea now?" How does counsel answer that without discussing the testimony? Or suppose the defendant mentioned a potential witness during his testimony that counsel wants to track down. How do you have that conversation without discussing what the defendant said?
Those are really concrete examples of why this rule might be unworkable. And Villareal raises an even more serious concern. What about perjury? Defense lawyers have an ethical obligation to prevent and correct false testimony. But under Texas's rule, counsel can't discuss the testimony to figure out if it was false.
Right, and that puts defense attorneys in an impossible position. They're officers of the court who must ensure truthful testimony, but they're prohibited from discussing the very testimony they're supposed to monitor.
Villareal also argues that this rule destroys the attorney-client privilege. The only way to enforce it is for the judge to ask, "What did you talk about last night?" But those conversations are privileged. And if clients know their overnight conversations might be revealed to the court the next morning, they're not going to confide in their lawyers. That defeats the whole purpose of the attorney-client relationship. So that's Villareal's case. Perry already resolved this. The rule is unworkable in practice, and it undermines fundamental attorney-client protections.
Now, let's look at how Texas responds, because they've got some clever constitutional arguments too. Texas's main move is to reframe what Perry actually said. They argue that Perry endorsed qualified conferral orders even during short recesses, noting that judges may permit consultation between counsel and defendant during a recess, but forbid discussion of ongoing testimony. So Texas is saying if qualified orders are okay during 15-minute recesses, why not during overnight recesses? The constitutional principle should be the same regardless of timing. Texas also makes a more sophisticated argument about what Perry really means. They say the difference between Geters and Perry isn't the length of the recess, It's the substance of what gets discussed.
Right. Texas argues that Perry established that discussing ongoing testimony is never constitutionally protected, while discussing trial-related matters like plea bargains and witness availability is always protected. So the question isn't how long the recess is, it's what type of communication you're restricting. That's actually a pretty clever reading of Perry. Texas is saying that testimony discussions aren't protected speech under the Sixth Amendment, so restricting them doesn't violate the Constitution.
And Texas provides this helpful illustration. Counsel telling the defendant what to say and how to say it in response to upcoming questions the following day is properly prohibited. However, counsel advising the defendant to take the plea deal after poor performance is constitutionally protected.
Texas also argues that the rule is workable because defense counsel in this very case said they understood it and never complained about compliance problems. If it were really impossible to follow, wouldn't we expect to see some evidence of that in the record? Plus, Texas raises some interesting policy arguments about fairness and truth-seeking. They argue that without these orders, defendants who happen to get overnight recesses during their testimony get an unfair advantage over defendants who testify straight through.
So Texas's argument is basically Perry allows qualified orders, testimony discussions aren't constitutionally protected anyway, the rule is workable in practice, and it serves important truth-seeking and fairness values. And here's something really interesting about the current court's jurisprudence that might influence this case. We've seen the court become more skeptical of broad constitutional rules that are difficult to administer.
Right? The court has emphasized workability and bright-line rules. Texas might argue that Villareal's approach would create endless litigation about what constitutes coaching versus legitimate advice, while their rule creates a clear, administrable standard.
But Villareal could flip that argument, saying that Texas's rule is the one that's unworkable because it requires courts to make impossible distinctions between testimony discussions and strategy discussions.
Looking ahead to oral arguments, what are you going to be listening for?
I'll be really interested to see how the justices react to the practical examples both sides raise. When Villareal's lawyer talks about the perjury scenario or the plea negotiation scenario, do the justices seem convinced that those conversations are impossible without discussing testimony? And I'll be watching for questions about Perry's scope. Do the justices think Perry already resolved this issue in Villareal's favor? Or do they see room for the kind of nuanced balancing that Texas is proposing?
The federalism angle could be interesting too. Most federal circuits have rejected Texas's approach, but several state Supreme Courts have embraced it. Does the court see this as an area where states should have flexibility to develop their own rules?
Plus, given this court's emphasis on text and original meaning, it'll be fascinating to see how they analyze the phrase assistance of counsel. Does that phrase, as originally understood, include assistance on all topics at all times?
Although there's an interesting historical wrinkle here, defendants couldn't even testify in their own defense when the Sixth Amendment was ratified, so this specific issue couldn't have arisen originally.
That's a great point. This is one of those cases where technological and legal developments have created constitutional questions the framers never could have anticipated. You know, this feels like one of those cases that could have significant practical impact regardless of how it comes out. If the court sides with Villareal, it could affect how trial courts manage testimony scheduling and overnight recesses across the country.
And if the court sides with Texas, it might encourage more trial judges to use these qualified conferral orders, which could change the dynamic of how criminal defendants interact with their lawyers during trial. The stakes are particularly high for defendants who testify in their own defense, which is often a make-or-break moment in criminal trials. The ability to consult fully with counsel during breaks could be the difference between effective representation and a conviction.
What's also striking is how this case illustrates the broader tension between different models of the adversarial system. Is the goal to let each side present their best case with full advocacy? Or is it to create conditions most likely to produce accurate fact-finding?
That's exactly right. And different justices might have different intuitions about where that balance should be struck. We'll definitely be covering the oral arguments when they happen, so make sure you're subscribed. This is the kind of case that could produce some really interesting exchanges between the justices and the advocates.
Thanks for joining us for this deep dive into Villareal versus Texas. It's a great example of how seemingly simple constitutional text can generate complex questions when applied to real-world trial situations.
As always, if you found this helpful, please rate and share the podcast. And if you're a prosecutor, criminal defense attorney, or trial judge, we'd love to hear your thoughts on how this issue plays out in practice. Thanks for listening to SCOTUS Oral Arguments and Opinions. Talk to you soon.